Property manager is not required to hold prepaid rent. Facts: the brokerage represents the landlord. The tenant has requested to prepay all rents at the beginning of the lease term. Issue: can the brokerage deliver the prepaid rent to the landlord, or must the brokerage hold the money in trust in the event the landlord breaches its obligations under the lease, i.e., the property is foreclosed during the lease term? Answer: a property manager does not have an obligation to hold prepaid rent in trust in the event the landlord breaches the lease. A landlord is entitled to demand the rental funds when they are received, less any property management fees, regardless of whether the tenant pays on a monthly basis or in advance. Lines 63 to 64 of the AAR Property Management Agreement provide, for example, that broker shall not disburse tenants' refundable security deposits, prepaid rent, or other prepaid funds to owner until earned unless instructed otherwise by owner. If, however, the broker retains the prepaid rent, it must be held in the broker's trust account. Property manager must honor timeframes in 5-day notice. Facts: the property manager presented a 5-day notice to the tenant, which incorrectly specified the date that payments would be accepted that was after the 5-day period. Issue: must the property manager honor the later date before proceeding with a forcible entry and detainer action? Answer: yes. Discussion. Pursuant to AAC. Paragraph R428-11001A, a licensee is required to deal fairly with all other parties to a transaction. In this instance, the property manager's inadvertent inclusion of a date later than the 5-day period provided for by ARS FAR 33-1968B has created an expectancy on the part of the tenant that additional time will be afforded within which to bring the rent current. As a result, the property manager must honor the later date provided in the 5-day notice. Property manager must maintain records for 3 years. Facts: a landlord and his property manager became entangled in a dispute regarding the cost of a repair performed at the subject rental property. As a result of the dispute, the landlord has demanded that the property manager produce receipts for each and every repair performed at the property at the direction of the property manager over the last 5 years. Issue: must the property manager comply with the landlord's request? Answer: see discussion. Discussion. ARS, paragraph 32-2175C, requires property managers to keep all financial records pertaining to clients for at least 3 years from the date each document was executed, including bank statements, canceled checks or bank-generated check images, deposit slips, bank receipts, receipts and disbursement journals, owner statements, client ledgers and applicable bills, invoices, and statements. Therefore, although the property manager is not required to produce 5 years of receipts, 3 years of receipts will need to be conveyed. Property manager must separate personal funds from funds held in trust. Facts: the broker manages several properties, some in her capacity as a property manager and others in her personal capacity. Sometimes it becomes necessary for the broker to turn over the collection of past due rental payments to a collection agency. When the collection agency is successful in collecting past due amounts, it sends the collected funds to the broker in one check. The funds often include monies collected for the property management firm's accounts, for the broker's personal rental properties, and for closed accounts previously managed by the property management firm. Although the broker has separate accounts for her personal rental properties and the property management firm, the broker does not know how to handle the combined funds she receives from the collection agency. Issue: how does the property manager avoid commingling funds? Answer: within 3 banking days after receiving monies, a property management firm shall deposit the monies in the property management firm's trust account for the benefit of the owners. CARS, paragraph 32-2174D. Commingling monies belonging to others or personal monies is prohibited. Accordingly, the broker should insist that the collection agency send separate checks. One check received in connection with personal properties, and another check for money received for clients. Property manager not obligated to report felony. Issue: the property manager furnished the 2-day notice to inspect the tenant's apartment. The tenant was not home at the time of the inspection. During the inspection, the property manager saw a handgun with a silencer. Is the property manager required to notify the police of this handgun with a silencer? Answer: no. Although a handgun with a silencer under certain circumstances is a felony, ARS Paragraph 13, 3101A, 8, E, a real estate licensee, or any other member of the general public, has no obligation to report a felony to the police. Note: inasmuch as a felony is being committed in the tenant's apartment, however, there may be grounds to terminate the lease. CARS Par 33, 1368. Rental property on leased land. Facts: a broker is contacted by a landlord who owns a manufactured home on leased land. The landlord wants to enter into a property management agreement with the property manager to manage the rental. Issue: can a property manager manage a manufactured home on leased land? Answer: yes. Discussion: pursuant to ARS Parv 414047 3-4, it is unlawful to engage in the business of brokering the sale of a manufactured mobile home without a license issued by the Office of Administration. However, there is no prohibition for performing property management services for a landlord of a dwelling that is affixed to the leased land.